Okay, folks, let's get started. We're talking now about declination practices, both the individual case-level declinations that prosecutors pursue, as well as declination policies that apply to the entire office and entire classes of cases. Now, this is part of the overall topic of screening of charges. You could think of the potential charges out there in the world as being screened out so that the most important ones go forward and the ones that are not viable for some reason or another get screened out at one level or another. Lots of actors have a screening function. The police, of course, have an important screening function. Both individual officers and entire departments help decide which cases are sent over to the prosecutor's office. Judges have some screening function at, say, preliminary hearings. Grand juries screen a few cases, but in terms of numbers, those aren't really especially important. The really important screening function among courtroom actors would be the prosecutor. Now, the prosecutor's screening function in the United States is a good bit more important than it is in some other places in the world. There is a tradition within the civil law world called the principle of legality that suggests that prosecutors really are supposed to stamp for approval any cases that have adequate evidence and move on to allow others to evaluate the case. In the United States, the tradition instead is that the prosecutor might screen out some cases that are perfectly legitimate, well proven, but for some reason not important enough to go forward. You have here examples from the Italian Constitution and the German Code of Criminal Procedure that embody this principle of legality. It's probably not an accurate statement of reality on the ground, but this principle does embody an aspiration for these systems, and it's not built into our vision of the prosecutor in the United States. Here the idea is that the prosecutor is choosing among cases and sorting out the most important from the least important. Now, there are some areas where prosecutors in the U.S. declare ahead of time that we are not going to be sorting these out. We're going to go forward with all of these that we possibly can. That's most common in the domestic violence charging arena. Florida statutes has an interesting strategy. It gives the job to specialists. It instructs all of the state's attorneys, the leadership in each of the local prosecutor offices, to develop either a specialized unit or specialized prosecutors who will handle these cases. Adopt a general pro-prosecution policy to favor criminal action instead of other responses to domestic violence. But then give the job to the specialist, and they can make choices even over the objections of victims if necessary. It's a little different from the Wisconsin statute, where the strategy is that every DA has to write, not just articulate, but write a policy that encourages the prosecution of domestic violence offenses. This written policy in every office should instruct attorneys that they should not be considering things like the relationship of the persons involved or the consent or lack of consent of the victim of the alleged crime. Shouldn't be based simply on the lack of visible injury. So these are traditional grounds that have come to be disfavored for dismissing cases. And the Wisconsin statute also requires timely action, quick action, within 2 weeks from the time that the complaint is received. So it's not so much give it to specialists, but whoever you give it to, they have to avoid these disfavored grounds for declination, and they have to move quickly. Another interesting feature of the Wisconsin statute is that it calls for every district attorney to submit an annual report to the State Department of Justice, and it is a report designed to track attrition. How many arrests, and then from those, how many result in prosecution, and from those, how many actually result in convictions. Compare those statutes to the prosecutor office policy in Duluth, Minnesota. You see here the courthouse where these prosecutors work. And this is a somewhat more detailed policy. Try to avoid continuances so that we get this done quickly. Always subpoena the victim so that it's not their choice whether they're testifying against their loved one. Negotiate a plea based on something other than your caseload objectives. Negotiate a plea that serves the general safety purposes for the victim. Review the files of the police that were the near misses, the ones that they nearly had enough evidence on, so that you can advise them on investigative strategies going forward. Stay in contact with the local domestic violence shelter so that they have some sense of which cases are going forward and when there might be a defendant who's not detained, who is out there and possibly posing a threat. So all of this detail goes into the policy, really just codifying sort of best practices for the prosecutor. Notice that legislatures try to stay away from this level of detail. They talk more generally about asking the prosecutors to declare themselves, but not telling them in real specific terms what they have to declare. When we get together, you should be ready to think and talk together about how domestic violence as a group of crimes came to be the subject of so many of these no-drop policies. Now we'll turn to the opposite side of the coin. We have been talking about those cases where prosecutors are either required or encouraged to bring charges. Now we'll talk about those cases where the prosecutor declines to bring charges, a declination. This could happen either at the individual case level, or it may be that for certain kinds of cases, the prosecutor's office as a whole has a generalized, articulated policy that would encourage prosecutors not to go forward for certain kinds of cases. How often does this happen? A lot. In some places, more than half of the files presented to them by police would be declined. In some places, the police have direct filing authority. They can bring it to the prosecutor and file it in court at the same time. In those settings, the prosecutor's declination just takes the form of an early dismissal from the court system. But in most places, it's the prosecutor's choice whether to initially file the case in court. And when they say no, that's a declination. It happens quite a bit. Obviously, this depends on the nature of the relationship with local police. If the local police are always bringing in cases that the prosecutor does not think is viable or is not a high priority, then you're going to be declining more. But if you have a better working relationship with the police and you let them know exactly what kinds of things you can go forward with, then your declination rate may go down. Why would you decline cases? You've got some indication of the reasons for declination from Assistant Attorney General Heyman from 1980. These are classic reasons given in response to a congressional investigation because they were shocked to learn that prosecutors sometimes don't bring charges. Assistant Attorney General Heyman was trying to explain why that might be the case. One reason, he says, is resource allocation. We just can't afford, given the number of attorneys that you're funding for the DOJ, we can't afford to bring all these cases. Another possibility, and more important, he says, is our obligations to justice. We have an obligation not to go forward with cases if they don't have strong enough evidence, if they don't have the sort of evidence that we believe a jury would take seriously. In that setting, we have to walk away from a case. We have to decline to file it before it ever gets started. Heyman also describes why declinations are so misunderstood. He says a lot of people really just haven't heard of this. This is not part of civics education in the United States. And people sometimes confuse scandalous behavior and criminal behavior. It might be that somebody's done something blameworthy, but it doesn't qualify as a crime, and it's the prosecutor's job only to focus on the latter, the crimes, not just all the blameworthy activity. And Heyman says there's really no place where we can and should talk about this. If we're investigating people, we can't go out talking about all the people we're investigating. That would be inappropriate and harmful to their reputations. So when we decline, we have some obligation to be quiet about it. We're not trying to fool anybody. This is just being responsible with other people's reputations. Now, there are some offices that go beyond this power of the individual prosecutor to decline charges in an individual case. And in these offices, the leadership in the office articulates some general policies, some general description of when the line prosecutors should decline charges. They may not write it, but they would articulate it. Now, there are some offices that decide not to articulate their policies. They just think it's better not to try to explain themselves and just to keep it on an ad hoc individual case basis. But for those offices that do decide to articulate their policies and to try to create some generally uniform approach to declinations, they give reasons along the lines described by Philip Heyman who's pictured here. So he says you can articulate policies in part to focus investigative resources. If everybody knows the kinds of cases that you're going to walk away from, they don't put a lot of investigation effort into those cases. It also makes it easier for the line prosecutor to explain to victims of alleged crimes or other people why it is that they're walking away from a case. This is just the way our office does it. It also gives the line prosecutor some leverage, some maybe backbone to deal with defense counsel. Sorry, I'd love to give you a deal, but my office doesn't allow that kind of deal. Notice how this set of purposes for dealing with defense counsel lines up with the availability of DOJ guidelines for the prosecution of business organizations. You've seen the 2008 version. Defense counsel influence is especially strong here. The ABA makes it a central priority to monitor the dealings of DOJ when it comes to possible criminal defendants among corporate entities and other organizations. And for these defendants, the charge matters a lot. There's a reputational effect involved here. You don't want to be a company that's indicted. You also don't want to be a company that's convicted, but the reputational hit of an indictment means that the charging decision is especially important for these defendants. Now we're going to talk about three different types of declination policies that you often see. The first type would be some general principles of declination without focusing in on specific types, just general considerations for the prosecutor in deciding whether to decline to file charges. One example of this first type of declination policy shows up in the Washington Statutory Code. These statutory principles are also elaborated in a little bit more detail for a number of the prosecutors' offices in Washington, like in Kitsap County or Kings County. These statutory reasons include these general principles such as prosecution wouldn't serve any public purpose, or it would defeat the underlying purpose of the law, or it would result in decreased respect for the law. Notice these reasons apply even if you have sufficient proof. The commentary gives some examples. For instance, there may be a prosecution that would be technically within the language of the statute, but just contrary to legislative intent. Or it may be there's an old statute, an antiquated statute. Maybe there's a de minimis violation. Technically, it's a crime, but it's just so small we want to walk away from it. Crimes against persons, violent crimes, are prioritized over property crimes. So for the property crimes, say the guidelines, the prosecutor has to have enough evidence to show that it will be probable that a conviction is going to happen. On the other hand, for crimes against persons, violent crimes, you don't have to have that strong a level of proof. You just have to show that there's legally sufficient evidence, what we would call probable cause. A second type of declination policy doesn't just talk in broad brushstrokes, broad principles of prosecution, but picks out particular low priority areas and says, if you've got this kind of offense or this kind of offender, normally you'll ignore these. You'll walk away and use your resources for something else. Typically, we're talking about nonviolent offenses, typically offenders with either no prior criminal history or a very minimal prior criminal history. The Department of Justice report from 1980 that you've read addresses some of these. Very often you have some kind of amount threshold that says if the loss to the victim falls below this monetary amount, then that's too small a case, small fry. Throw it back and fish for something larger. You also see these offense-specific or offender-specific policies in state prosecutors' offices. Some very common ones would be joyriding. Somebody steals a car and just drives it around for fun and abandons it somewhere. And a lot of prosecutors' offices will try to handle that outside the criminal system in some way. Also, very small amounts of loss from a theft will occasionally be ignored. Some assaults, as long as it's not the domestic violence context, but if it's people who are just shoving each other and nobody's really harmed, then that often would go on the list of lower priority crimes that we won't pursue. And finally, the third type of policy that you'll see for declinations involve what you might call procedural policies. That is, We won't tell you which cases to decline or not to decline, but we will tell you that before you decline a case, you've got to go through certain steps. You've got to jump through certain hoops within the office. If you're low down in the office, you've got to get a supervisor to sign off on this. Or it may be that you have to fill out a certain form, make a record so that if somebody has a question about this later, we can reconstruct what was on your mind. So some kind of procedural hoop to jump through that slows it down, makes you stop and think, makes you bring in the wisdom of other prosecutors. This is especially directed at people who are new to the office and lower down in the office. And sometimes you'll see procedural policies that are aimed at only particular crimes, like maybe violent offenses, including domestic violence offenses. For those high priority crimes, we will say you can only decline to charge these if you get a boss to sign off on it or fill out the right form or whatever the procedural hoops might be. So with those types of declination policies in mind, read through the examples that are before you and be ready to think when we get together to talk about what sorts of offices are most likely to adopt which types of policies. How would a smaller office respond to these choices? How might a larger office respond? Urban versus rural. Think through the match between types of offices and types of policies. We'll talk soon.